In this lecture, the focus is co-ownership in land law, what it is, how it arises, and the two main forms, joint tenancy and tenancy in common. Then we'll look at how to tell them apart, how each is created, and how each can be brought to an end. Co-ownership is simply when two or more people hold an interest in the same property, usually land. The key idea is simultaneity. Multiple people are owners at the same time, in relation to the same piece of property, even though the law may structure their interests differently. They hold an interest in the same property. That interest might be structured as one unified interest shared together, or as separate undivided shares. That difference is exactly what separates joint tenancy from tenancy in common. Co-ownership commonly arises in three ways. First, joint acquisition. People contribute together to obtain the property. Second, by gift. An owner grants property to two or more people, either during life or by will. Third, by operation of law. Statutes can make people co-owners automatically. Joint acquisition can even happen through adverse possession, as illustrated by Ward v. Ward, where co-tenants acquired another co-tenant share. And operation of law matters in intestacy. For example, where only one house exists, spouse and child can become entitled and hold as tenants in common. A concrete example of operation of law is Section 4 of the Interstate Succession Act 1985. If the estate includes only one house, the surviving spouse or child, or both, are entitled to it, and where it devolves to both spouse and child, the statute specifies they hold as tenants in common. There are two main types of co-ownership. Joint tenancy is built around equality and survivorship. Co-owners hold one undivided interest together. Tenancy in common allows separate undivided shares that can be equal or unequal, and crucially, there is no survivorship. Each share can pass to the owner's estate. In a joint tenancy, each joint tenant has an undivided interest in the whole property, with equal rights of use and enjoyment. The point is that no one holds a distinct slice, like 50%, in a physical or separate sense. Everyone is entitled to the whole, together. So undivided doesn't mean vague. It means legally the land isn't split into separate parts for each owner. The owner's rights overlap across the entire property, which is why joint tenancy has special rules like survivorship and the four unities. The distinguishing feature of joint tenancy is the right of survivorship, jus accrescendi. When one joint tenant dies, their interest does not pass under their will or to their estate. Instead, it is automatically absorbed by the surviving joint tenant or tenants, until eventually one survivor holds the whole. That's why courts describe survivorship as the defining mark of joint tenancy. In Finucane v. Teye, the Supreme Court approved McGarry and Wade's point that without survivorship, joint tenancy as a concept basically collapses. Joint tenancy traditionally depends on the four unities: possession, interest, title, and time. These are conditions that must exist together. If any one unity is absent or later destroyed, the law treats the co-ownership as a tenancy in common, at least to the extent of the break. Unity of possession means every joint tenant has an equal right to possess and enjoy the entire property. It does not mean everyone is physically inside the house at once. It means legally each has the same entitlement to use the whole, not just a designated corner. Unity of interest requires that all joint tenants hold the same kind of interest and for the same duration. The material ties this to Act 1036's notion of registrable interests, like allodial title, freeholds, usufructs, leaseholds, and customary tenancies. In joint tenancy, the interest type must match across co-owners. If one person holds, say, an allodial title, while another holds a usufruct in the same land, the unity of interest is missing. The consequence is severance. The arrangement cannot remain a joint tenancy and is treated as a tenancy in common. Unity of title means all joint tenants take their interest through the same event or conveyance, effectively the same title source. Unity of time means they acquire their interests at the same time. These unities explain why later transfers by one co-owner can disrupt joint tenancy. Under common law, if land is conveyed to two or more people without words of severance, words suggesting division, the presumption is joint tenancy. The courts examine the conveyance instrument itself to see whether the language points to undivided joint holding or divided shares. Words of severance are cues of division, like in equal shares or to be divided equally. The material also flags absolutely as language that can indicate a separate inheritable share, which pushes toward tenancy in common rather than a joint tenancy. Finucane v. Teye illustrates the approach. The court examined the deed of purchase, Exhibit B, looking for words of severance. Finding none, it applied the common law presumption. A simple conveyance to two or more persons, without severing language, points toward joint tenancy and a single undivided interest. Adintoa v. Owusu shows how wording can flip the outcome. The will gave property to the son and daughter for their use absolutely. The Court of Appeal treated that as creating a tenancy in common, and the Supreme Court affirmed. So drafting language can be decisive. Under Ghanaian law, the approach changes. Section 43(3) of the Land Act 2020 says a conveyance to two or more persons, except a conveyance in trust, creates an interest in common, not joint tenancy, unless the conveyance expressly indicates joint tenancy or survivorship, or clearly shows that intention. So you typically need express language, like as joint tenants, or survivorship wording, such as to them and the survivor of them. Alternatively, the document must manifestly show an intention to create joint tenancy. Silence alone won't do it under Act 1036. Determining a joint tenancy means terminating it, and the logic is straightforward. If an event destroys any of the four unities, joint tenancy cannot continue. The material lists several ways this happens: alienation, partition, homicide, acquiring a different interest, sale of the property, and mutual agreement or course of dealing. Alienation is a classic severance event. If X, Y, and Z are joint tenants and X transfers their interest to Q, Q takes through a different conveyance and at a different time. That breaks unity of title and time for that share. Y and Z may remain joint tenants between themselves, while Q becomes a tenant in common with them. Partition ends co-ownership by turning shared entitlement into separate ownership of distinct portions. Once partition happens, unity of possession is destroyed because each party is now entitled only to their allocated portion. In Adobla Vakise, the effect of partition was that each group became the absolute owner of its portion from the date of the decision. Homicide can also sever joint tenancy because the law will not allow a killer to benefit from wrongdoing. The forfeiture rule blocks the right of survivorship in that scenario. In Re K Deceased, the court discussed how the forfeiture rule operates and also noted statutory power to modify its application in particular circumstances. If a joint tenant acquires a higher or lower, or simply different, interest in the property than the others, unity of interest is no longer present. The material explains that this kind of mismatch disrupts the joint tenancy framework because joint tenancy requires identical interests held together. A sale of the property ends the co-ownership because ownership transfers to a new person. Once the co-owners no longer have an interest, they no longer have any right to possess or enjoy the whole property, so unity of possession disappears, and the joint tenancy is effectively determined. Joint tenancy can also be severed by mutual agreement or by a course of dealing that shows the parties no longer intend to hold jointly. In Burgess v. Ronsley, conduct around an attempted sale of one party's share was treated as sufficient evidence of severance, an intention inconsistent with continuing joint tenancy. Tenancy in common is different. Co-owners hold separate, undivided shares in the same property, and those shares can be unequal. The key is that each tenant's interest is inheritable. When they die, their share passes to their estate or successor, rather than automatically to the surviving co-owners. The main characteristics of tenancy in common are first, no right of survivorship. Death does not shift shares to co-owners. Second, unity of possession is the key unity. Each tenant in common can use and enjoy the whole property. Third, other unities, interest, time, title, may exist, but they're not required. So unlike joint tenancy, the legal pathway on death runs to the deceased tenant's estate. That's why tenancy in common is often described as holding an inheritable share. Each co-owner's portion is capable of being transmitted by succession. Tenancy in common can be created in two prominent ways highlighted in the material. One is by operation of law. Act 1036's Section 43 makes interest in common the default for conveyances to two or more people. The other is through words of severance under common law, which indicate divided shares. Tenancy in common can end in several straightforward ways. It can be determined by sale, interests transfer away. It can end if one tenant acquires the interests of all the others, consolidating ownership. And it can be determined by partition, which converts shared ownership into separate ownership of distinct portions. The big takeaway is to separate the two models. Joint tenancy is defined by survivorship and the four unities, and it can be severed when a unity is destroyed. Tenancy in common has inheritable shares and mainly requires unity of possession, and under Act 1036, it's often the default unless joint tenancy is clearly expressed.